Welcome to our first session of the new year. I'm not sure now whether we should talk about a session of the Communities and Local Government Select Committee or a session of the Housing Communities and Local Government Select Committee as well. We have to respond to the government's change of name for the department today. But anyway, you're still welcome in whatever name we're meeting. And say that as an evidence session, we've got a slightly unusual situation in that we've got almost two sessions rolled into one. It's the first evidence session of our inquiry into the private rent sector, and also the first session of pre-legislative scrutiny of the draft tenant fees bill. We're taking them together with the same panel of witnesses because the two are so clearly related and intertwined that it would be sensible to do that, and that's how we're approaching things today. Before we pass over to you as witnesses, I'm just going to ask members of the committee to put on record any interests they have which are particularly relevant to this inquiry. I'm a Vice President of the Local Government Association. I also have one property which I rent out as well. Yes.
I'm a councillor in my staff team.
I am a councillor in Gateshead Metropolitan Borough Council.
I employ a councillor.
I also employ a councillor for the staff team.
I employ two councillors as part of my staff.
I'm a non-representing member of the Royal Institution of Chartered Surveyors.
I'm a Vice President of the LGA.
I'm a Vice President of the LGA and have a small property portfolio.
Okay. Right, that's our interest on the record. Just to help the committee, if you could just go down the table and say who you are and the organisation that you're here representing today, that would be helpful.
I'm Professor Ian Loveland. I'm Professor of Public Law at City University London.
I'm Kate Webb. I'm Head of Policy at Shelter, the National Housing and Homelessness Charity.
And I'm Dr. Julie Rugg from the Centre for Housing Policy at York University.
Okay, thank you very much for coming on this and talking to the committee on this important subject. Just to set the scene to begin with, the private rent sector has been growing significantly in the last few years. Have the nature of the tenants who's actually there in the private rent sector, who's renting property, and landlords as well, have they changed with that growth in the sector in the last 10 years or so?
I mean, certainly if you look at the profile of tenants, there's been some very significant changes. Most notable, probably I'd say, families with children. About 10 years ago, you were looking at 1 in 10 children growing up in the private rented sector. It's now actually 1 in 4. So this perception that many of us still have around the sector largely serving sort of young professionals and students is really now a thing of the past, and it's now catering for people with children, people for much longer periods, and generally a much kind of broader and more diverse age group.
I think it's interesting to think about the dynamics of the sector at the moment. We're looking at a much more mature sector, and things have gone on. Landlords themselves are becoming more mature, as it were. I think it's one of the things we're looking to do is look at the demographic in a lot more detail. There are still a lot of single people, a lot of couples in the private rented sector. Certainly I agree we're seeing more families in the private rented sector, but I think we really need to understand why and how long those families are staying in the private rented sector. One of the things that we don't understand about the sector, it's made up of lots of different things. There is a lot of churn in the sector. We need to understand what the churn means.
I wouldn't wish to make any general comments, Chair, but I would say from my experience as a barrister practicing in the area of housing law, it was notable to me over the last 5 years that I was representing an increasing number of tenants who had been placed in private sector accommodation by local authorities in discharge of their homelessness responsibilities. When I began my practice at the bar in the early 2000s, that was quite rare, but it was very frequent by the time I stopped my practice in 2016.
And what about the nature of landlords? Have they been changing as well, or have we got basically the same group of people renting who were renting 10 years ago?
I haven't seen data to suggest that there's been a big shift in the profile of landlords. I mean, certainly I think one of the things which has been quite striking is that a move towards larger, more institutional landlords hasn't happened. And for reasons which aren't entirely clear to people, the hope that you'd get more institutional investors coming into the private rented sector and bringing in a more kind of professional subsector doesn't really seem to have happened. You still seem to have a dominance of the sort of amateur landlord with one or two properties to their portfolio.
I think, again, similarly, we've really got to sort of understand this data a bit better. There are a lot of smaller landlords, but quite a large proportion of the private rented sector is in what I would call portfolios. So we've got a lot of property owned by one landlord, certainly, but as part of a larger portfolio of properties. So we've got to distinguish between the pension landlord who's looking for one property to augment their pension, and landlords who are single landlords with a portfolio of properties that they're developing. And at the same time, we've also got to understand that some landlords are now starting to divest themselves of their properties because they themselves are reaching pension age, they're retiring. So that's one of the sort of, we need to kind of understand what landlordism does in somebody's life course. They go into landlordism, they come out of landlordism, and we need to understand what that looks like, because otherwise I think our policy is tending to be rather diffuse. It's not really focusing on the problem that we see in the market in terms of management.
Although that trend isn't new, is it? The fact that people are often landlords for quite a short cycle of their life, maybe a sort of 10-year plan, and then they'll release the property.
Well, there's a distinction between somebody who's bought a property and with the buy-to-let generation, as it were, that are then coming through and thinking about them retiring and moving out. So they've had their property for quite a long period of time. The pension landlords will have their properties for a long period of time. Actually, compared with the portfolio landlords who might churn their properties to make their portfolios work better. So there's lots of different kinds of activities and actions going on, and it's very hard to generalise to say landlords are of this type. We need to sort of like pin that down a little bit better.
Yeah, I just got to pick the point about generalisation. We're talking about small landlords. They can actually be very different, can't they?
Very diverse.
They can be landlords who've got a very small portfolio, but they want to be landlords. They see that as something they want to do, as opposed to someone who inherits a property, sometimes a right to buy property, which they can't get rid of, and they end up being stuck with it as a landlord, which is...
Yeah, that's probably the more important distinction, not necessarily the size of portfolio, but their intention of whether they are planning to make a business as a landlord or whether it is a pure accidental landlord because either they can't sell or they're waiting for the market to increase.
I think you're exactly right. I think what we need to do is try and estimate how big of the part of the market that is. These are people not intending really to be landlords for the long period because they weren't intending to be landlords in the first place. And I think we need to pin down what that number looks like. It's going to churn quite a lot. But if it's a quarter of the market that's churning quite a lot because we've got landlords in that category, we need to understand why, because they're a very hard group to sort of like focus attention at, policy attention at. And we need to understand, is it good for the market that we have that, or do we need to think about how we deal with that kind of landlordism?
Right, so I suppose the next question, obviously then, is what has this done to the standard of accommodation in the private rented sector? Is it getting better, or is it getting better in parts and worse in parts? What's your overall view of it?
Well, looking overall, the private rented sector quality in terms of the decent home standard has improved. So 2006, 47% of the market was not decent. That's down to 29%. So we've seen an actual improvement. That improvement can't be explained simply because of there being newer properties in the private rented sector, because the improvement goes beyond that sort of proportion. I think it's important for us to understand what that improvement is about, but at the same time being mindful that we still have disrepair in the sector, and that disrepair is disproportionately affecting some people rather than other people. And I think it's, for us, having done some recent evaluation, the people that it's most impacting on are single-person households, it's people over the age of 55, it's people who are unemployed, whose status is unemployment. And also, for us, the really important thing is that non-decency increases as the tenancy increases. So it's not as much about churn, i.e. lots of properties that are churning. It's some people living in properties for a long period of time where that property quality is declining over a long period of time. I think it's important to think, actually, a lot of that looks like HMOs. We're talking about older people living in HMOs, having kind of the sticky end of the bargain. And that's something that we really need to be thinking about, because that's where a lot of the policy attention has been in the past few years.
I think the sort of improvement, though, is a very complex picture, because while it's certainly true that the proportion of private rented homes not meeting the decent home standard has fallen, the absolute number has actually still increased, so that the growth we're seeing in the sector has included a large number of non-decent homes. And certainly, I mean, our service user stats are always going to be swayed by who we're marketing to, for instance, but we've continued to see a big increase in the number of private renters. So I think we would certainly not be confident making a call that
I absolutely agree with you. The absolute number of people in non-decent property has gone up, without a doubt. The proportion has shifted, but the numbers have improved, have increased, and that's really important to underline that.
Okay. Mark.
Again, related to that. So when compared with other tenures, how satisfied are tenants in private rented accommodation?
So they tend to be the least satisfied, and they're the most likely to be living in a non-decent home. So they do appear to be the sort of unhappiest, and also they are paying the most for the privilege. The average private rented cost is more than the average social rent or indeed mortgage repayment.
And rogue landlords, the term rogue landlords is obviously bandied about in the press quite a bit. What's your estimate of people you would genuinely class as rogue landlords?
So we don't have an estimate for the sort of number or proportion of rogue landlords. But again, I think actually part of what we need to do here is drill into the complexity, because I don't think it would be fair to characterise the sector as split between rogue landlords and a functioning sector. You have a lot of shades of grey in between, particularly among the accidental landlords who are often working from a position of huge naivety, and because they're not seeing themselves as in the sector for the long term, are very hard to reach. And I think there's a meaningful kind of motivational distinction between the rogue landlords who at the roguest end are, genuinely criminal and also baking that into their business model. They accept the cost of very high fines because they know that they will make that back in the rent repayment. There is a big distinction between that and someone who inadvertently allows the category 1 hazard to remain in the property because they just don't know any better, and have a tenant who also isn't aware of their rights or how to go about getting enforcement action. So my overall point is I don't think it's incredibly helpful to try and distinguish a kind of 10% rogues and assume the problem is there. You do have to operate across the complexities of the different landlord types.
Who would you reasonably describe as a rogue landlord?
I think we would say it's someone who's actually breaking legislation, so sort of things like illegal eviction, harassment of tenants, certainly the emerging trends that you're seeing around sex for rent or rent for sex. I can't remember which way around is correct, but landlords who sort of sexually exploit their tenants in exchange for someone staying in the property, the beds in sheds model, the extreme overcrowding in HMOs. I think that end of the market, everyone would be very confident in describing as rogue. I think what's more problematic is when you have the person who is renting out their deceased parents' flat and they just don't know about their obligations around gas safety, to ensure that mould and vermin and that sort of thing are dealt with.
Okay, thank you.
I think with regard to satisfaction, I think certainly there's tenure difference, but at the last EHS, 82% of private tenants were satisfied with their property. And I think it's important to note there is some parts of the market are working, and I think we've really got to understand which parts of the market are working and why. It's very easy to castigate the whole sector and say it's not working. If you understand that bits of it are working, we understand why it's working, and then we can think about how we can replicate those characteristics across other parts of the market, which sounds a little naive in some senses. But part of it is really around the kind of rents that people are able to pay. The rogue landlords distinction I find very, very unhelpful. It's not useful. I think it's important to note that some criminals actively engage in letting properties, and it's criminal activity. These are people who are also criminals in other senses. And I think we need to be alert to the fact that this kind of criminal activity operates. I agree with Kate that there are some people more or less aware of their regulatory responsibilities. Sometimes they're woefully inadequate, ignorant, and sometimes they really should care more, to be honest. And I think that is definitely the case, and more information needs to be available to people. But at the same time, I think there is a responsibility around the regulation. The regulation is hugely complicated. It really is very, very complicated. And I'm sure you will know as landlords, part of yourselves, you're thinking, I want to do the right thing. Finding that information can be very, very difficult. And local authorities are very hard pressed to get that education information out to people. So I think it is very complicated thinking why there are problems in the sector, because the reasons for the problems are very, very complex to understand.
Right, thanks. Yeah, we're going to move on then to the legislation and regulation. Helen.
So I think I know part of the short answer to this question, but if you could unpack it a bit more, I'd be really grateful, is that the range of legislation from which local authorities derive their powers to intervene on behalf of tenants in the private rented sector, is it coherent, is it fit for purpose at the moment in your view?
I think it's a quick no, really. I think we've got all sorts of problems. I think one of the big issues that relate to some of this legislation, it tends to split issues between condition-related issues, management-related issues, issues that relate to letting agents, as we'll come on to in a minute. A lot of this doesn't really fasten up. A lot of it doesn't really link up. There's a sort of a thought that regulation that sits around property licensing will be actively improving the property quality of the licensed properties, but that's not necessarily the case. The evidence is poor for that. So the legislation which we think is solving a particular problem isn't necessarily solving that problem. That's quite important to understand. And a lot of local authority officers will probably be queuing to say this legislation doesn't work because of X, Y and Z. We've got a lot of legislation that is been brought in very quickly. It's not been drafted very well. There's information that, and changes that come on top of that. And I think it's kind of like a ship with lots of barnacles. All of these things are being added on to other bits of legislation. And now we're in a situation, it's very hard for a local authority to think, which bit of legislation do I use to deal with this particular problem? And then finding, actually, none of the bits of regulation that I've got to work with will deal with this particular problem, because none of it fastens up.
Yeah, I think we would certainly agree. And I think it's unfortunate because a lot of that piecemeal nature has come from good intentions. There have been some very kind of rapid interventions announced in recent years to try and improve local authorities' tools, and a lot of them on an individual basis have been welcomed by both the local authority and by us. But I think you do have to acknowledge that the overall result is a framework which is piecemeal. We recently commissioned the Universities of Bristol and Kent to do a review of legislation covering conditions in both the private and social rented sectors, and the conclusion of the professionals they spoke to was that it isn't fit for purpose. And part of that is because of the kind of incoherent way it's developed, where you have bits of legislation that relate to kind of public health, essentially, often still steeped in very Victorian notions. You have other bits that are coming from a kind of consumer regulation standpoint. You don't have an overarching piece of legislation which actually says, these are your rights, these are your responsibilities, this is how local authorities will enforce it.
Thank you. No, okay. In what areas, in your view, does the legislation currently provide insufficient protection for tenants?
So I think a big frustration that we still see is around sort of enforcement orders and prohibition notices and sort of the framework coming out of the housing health and safety rating system. You've got a very practical problem that actually the housing health and safety rating system hasn't been updated for about 20 years now. So a lot of the stats that underpin the assessment is out of date, and a lot of the examples which are given to local authority officers to help them work through the process are sort of actually too extreme. But a big issue you actually have, and I think this is a thing that we need to get onto, is that the sort of imperfect legislation very quickly rubs up against a severe lack of resources. So what we tend to see is a lot of local authorities favouring informal routes rather than going through the statutory process. And in some instances that might actually be really worthwhile, and there's a lot of good things local authorities can do on an informal basis. But when you look at the inconsistency across the country in terms of the number of local authorities who are serving enforcement notices, that suggests that there is something going on in terms of resources, but also kind of understanding and application of the law.
I would absolutely agree with that. I think that there are difficulties around the force of the legislation and the resources that they sort of implement that regulation just don't seem to match up. I was talking to a local authority just recently, particularly over the last few years, that the private rented sector has doubled in size in some areas, but the number of housing officers to deal with enforcement hasn't changed at all. So there was a local authority that told me there are 39,000 properties in the PRS and 4 environmental health officers to deal with that, which on anybody's measure I think is inadequate.
Yeah. Could you say a bit more about the housing health and safety rating system and the areas where it's deficient at the moment, and how a review and an updating of that system might help local authorities to have more clarity?
I think it is a very complex system. I couldn't go into all of the 29 different components of the system to understand what they were. I think it was interesting to hear comments about how to work with that system. Really problematic, because I think there's something to be said around an environmental health officer's requirement and what somebody's saying, you know, this is a lettable property as far as I'm concerned. I'm not saying that people should have low standards, but I'm saying that some people would say, you know, this is not a concern for me necessarily, that this is a difficulty with this property, given we've got quite a high percentage of people being satisfied with the properties that they are in. Obviously, some of those aren't going to be fit for according to those standards, just looking at the data. So I wonder whether we might think about looking at those standards again and thinking about what is a reasonable standard that we should be working to, and whether that standard is literally too complicated for us all to work with very easily and cost effectively. Because if we're expecting landlords to be dealing with those regulations, they then have to deal with somebody who has sufficient knowledge to be able to understand how that system works. And that really posits that information in a group of people that are very, very heavily under pressure. We need standards regulations that are more readily accessible, that everybody can work with them on a commonsensical sort of right viewpoint, in my view.
I think that's true, and certainly one of the features of the housing and safety rating system and why it's so complex is it doesn't just look at the property in isolation, it looks at it in regards to who's living in it. So a property which is safe for one household might not be safe for another. I think on the question of kind of its opaqueness, I think that for us is one of the attractions actually of the Fitness for Human Habitation bill, that it's attempting to lift the baseline of those standards and put them in as sort of the base expectation for what it means for a property to be fit for human habitation. And then it's still up to the individual whether they choose to pursue that. But it sets a very clear expectation for landlords and tenants of what the basic level of decent conditions looks like.
Can you say a little bit more about the resourcing issues that local authorities are experiencing at the moment? So I'm interested in that the erosion, the loss of capacity within local authorities. I'm interested in the way in which tenants experience making a complaint to a local authority and the response that they're getting back, and then the capacity of local authorities also to take cases through the courts and actually bring successful prosecutions.
I mean, I think in our experience, it's the capacity issue is the real issue. You know, while local authorities have had both growing private rental sectors in the vast majority of areas, they've had increased responsibilities themselves, but the resources they have shrunk. And it's no surprise that if you look at the activities they're actually taking out, the proportion who are taking statutory action has fallen. So they don't seem to have responded to the new powers in the growing sector in the way you'd want. If anything, it's gone the other way. And certainly when we talk to local authorities, it is that lack of resources which is the number one concern rather than lack of powers. And I think we have to be really cautious about that this is probably going to get worse. Certainly if you look at recruitment into environmental health, what they consistently tell us is it's incredibly difficult, because if you're a young graduate, why would you go into a profession which is increasingly ill-resourced by the local authority? What this does mean for individuals is you are effectively subject to a postcode lottery, depending on how many officers there are in your council, whether they favour a formal or an informal approach, where you rank in the grand scheme of things, because there is, whilst there is sort of a duty to investigate all category 1 hazards, I think our experience is definitely that there is a kind of informal ranking where local authorities do, you know, for understandable reasons, try and prioritise the most severe cases. But that does mean for a tenant that at the moment you are left in a very frustrating situation where you feel you have no recourse if you are living in substandard accommodation.
Absolutely, I agree. I think Shelter's in the best position to comment on people's experience of complaining, certainly from talking to tenancy relations officers. It's that long time frame between a complaint and an environmental health officer able then to go and visit and deal with that complaint is so protracted in some instances. I'm sure that there are tenants who might just simply move to, you know, choose to move out rather than wait around. And similarly, where a local authority is simply seeking to pursue a case through the court, sometimes the tenant is simply not around long enough to take that to court and to deal with it adequately. I think the problems are with the legislation is not very well framed, local authorities aren't well resourced to deal with it, and the courts aren't sitting well enough in response to those two problems. So we've got problems on all three fronts, in my view.
I think the other factor we have to consider with the court angle as well is, of course, the loss of legal aid. So you can now only get legal aid. You're obviously going to be subject to the income threshold, which excludes a large number of low-paid tenants. But also you have to be facing very serious disrepair. So there's an awful lot of people who we would argue should be able to get recourse through the courts who just aren't eligible until they reach that real kind of danger crisis point.
Is it fair to say that we have a system of regulation and enforcement which isn't fit for purpose in any sense at the moment?
I think we would sort of lean towards that conclusion. And as I say, there's something about that which is kind of problematic when there has been a concerted effort to improve the tools available for local authorities, and I don't think that incoherence, it's not coming from a place of complacency. You know, if you look at government focus on the private rented sector, work on conditions stands out as being much better than work around affordability or stability, but because it has evolved in those piecemeal ways, it hasn't resulted in a coherent and crucially a well-resourced sector.
Ultimately, we're after the best outcome for the tenant in terms of the housing that they're going to be living in and the condition of it. Interesting that you've both spoken about also almost the amateur landlords being a problem, people who seem to have just accidentally or by other means on a smaller scale become landlords. Is it the case, and given that some local authorities are choosing an informal route rather than a formal route, is it the case that we're concentrating all of our efforts on the legislative route, whereas we could perhaps be looking at more informal routes as well? And is it a case of education and information and being part of this solution?
Yeah, I mean, certainly I'd say some local authorities are already doing that very well. We've certainly come across examples who have put a lot of effort into things like landlords forums, where you can try and reach out to some of those landlords and try to educate them. I think there's more that could be done. I mean, it does strike me as a little perverse that if you speed in your car, you have to go to a one-day training course to learn how not to do it. But if you decide you're going to rent out someone's home for the next kind of year or so, there's no requirement to go through even the most basic kind of e-training in order to do so. So I think certainly that could be something that's looked for next to augment the sort of powers that local authorities have. What are the kind of softer tools available to them?
Absolutely, I mean, I agree with that. I think there is a sort of presumption that you don't really need to know a lot to be a landlord, and entirely it's hugely problematic when you're talking about something as important as somebody's living environment. That we have got this part of the market that does churn, and that's not, I don't think that's going to stop. But we've got to think really quite hard about how rigorously we approach that. You know, we've got to think about what's the best way of dealing with that, and is it about a culture change? That we think about, actually, everybody needs to know this is not something you can do on a kind of car boot sale basis. This is something that needs to be done properly if it's going to be done at all. And that takes a kind of culture shift in the way in which we talk about letting as it's not something you can do informally. It's something that you really need to sort of understand what you're doing before you get into it. And I wonder, and I think it's interesting, perhaps further discussion, is what letting agents are doing in this situation. Whether we think that letting agents are really good in terms of they can bring that informality into a more formal part of the market and then create circumstances where the letting's better, or actually whether they're also, in some instances, part of the problem as well. So there's a range of things that we can think about, but I think we really have to begin to take this part of the market quite seriously. I don't think we just say these are all amateurs, it's kind of like they're a problem. Some of them aren't, but we've really got to understand what this problem looks like.
Perhaps following on from that last question, I wonder, Dr. Rugg, you've talked about barnacles, legislatively speaking. I wonder whether actually we would be better as a Parliament focused on spelling out to people clearly their rights and responsibilities, both tenants and landlords, consolidating the existing legislation, by all means incorporating the improvements coming forward. But the heart of this seems to me both an uncertainty and a lack of knowledge of people's rights and responsibilities on both sides of the table. And we're looking at another piece, another barnacle to come forward. Do you feel that will be an area where we should, as Parliament, be focusing on getting change made?
I think there's two things going on here. Telling people what there is and thinking about, actually, can we just make the whole thing simpler? Because that's a sort of a better option in some instances. I think looking at the sort of the guidance that's given by government is how to be a renter, how to rent it. Actually, that's really condensed, and you think, well, this is quite good because it's quite condensed. But actually, if taken into account it might be an HMO, then you probably have to have another leaflet, another type of letting, and it starts to get quite complicated. Even for people to understand whether they're living in an HMO or not, then understanding the rights and responsibilities that go on starts to become complicated, because it's hard at the moment to understand what is an HMO and what isn't. So I think there's something around less about let's just explain this complexity to people, and more let's just think, actually, maybe our focus should be getting rid of some of the complexity.
Fiona.
Thank you. So given what you were saying before when you were talking about regulation and enforcement, what do you consider the main obstacles are for a tenant to pursue a complaint against the landlord? Do you think that factors into it?
So I think there's a very practical barrier which touches on what we were just talking about, is that you need to know that you have a complaint and you need to know where to go. Certainly I've always been very struck when we've done work with tenants, when we've done sort of focus groups and asked them what do they want, their expectations are very, very low. You know, tenants say, well, I want my landlord to not let themselves into my property, which is, of course, already illegal. And I always have that in mind when I see the stats about the percentage of people who are satisfied, that actually we have extremely low expectations about the private rented sector. So I think people need to know what their rights are, which they don't necessarily at the moment. They need to know where they can go. And certainly I think most local authorities, it's fair to say, are not proactive about publicising their role, which I can't really blame them for when you think about how much they're lacking in resources. But I do think there's another kind of important factor, which we've sort of alluded to in the cultural aspect, that all of this is happening against massive growth in the private rental sector. And some of that has been among people who are quite affluent, who have choices, who have the ability to shop around potentially, but a lot of it has also been among people who have either been placed there by local authorities or would have ended up in social housing in a previous generation. And they are very aware that they have very, very limited sort of purchasing power in the private rented sector. You know, if you're on housing benefit and you have come across landlord after landlord saying no DSS, professionals only, you are very aware that your options are limited. And, you know, the existing powers as they are around retaliatory eviction are both kind of very narrow, but more importantly, very poorly understood. So you will be very, very cautious about putting your stability at risk by kind of rocking the boat and complaining about the landlord. So I think actually the temptation for most people in the private rental sector is just to sort of accept it. And either, as you said, sort of you assume that you'll be moving in 12 months' time, so it doesn't matter, or you just sort of grind your own expectations down and put up with poor conditions. Because, you know, when we survey tenants, we find more than half are reporting poor conditions in their properties. And when you're looking at that kind of endemic sort of disrepair and poor conditions, that can't just be a long list of people who are waiting for the local authority to take action. That has to be telling us something systematic, both about where conditions are, but also where people's expectations are.
And have they specified, like in these surveys that you're looking at, the obstacles to? So, for example, I think it's going to take too long. I don't think they're going to take me seriously. I don't think it's going to have a beneficial impact on me taking this complaint forward. Like, have they set out to you what the main obstacles
I'd want to go back and check the data and share it with the committee later. But certainly that fear of losing the tenancy is a big obstacle that we see. And certainly, actually, it is something that our advisors have to be very upfront with people when they contact us about poor conditions. Even with the limited protection that the Deregulation Act brought in, we do have to be incredibly clear with people that with AST legislation being what it is, making a complaint doesn't necessarily mean your situation get resolved. It might just mean that you're making a homeless application in 3 months' time.
Okay, so since the 1st October 2014, where there is a legal requirement for these agencies to be part of a legal redress scheme. There's 3 of them. Do you not think that has that had a benefit? Has that?
I think certainly I'd struggle to say that we've seen a kind of a real shift since then. I don't know what your experience has been from the data you've been looking at.
Do you think it's been effective?
I don't necessarily think it's been effective.
No. Okay.
But I think there are issues if people are going for advice and they're told that it's best not to complain because you might be evicted.
We don't tell people best not to complain, but it would be irresponsible not to explain to people that this is what could happen, this is what you would hope that would happen, but this is also what could happen. It would be deeply irresponsible to not tell people that their landlord has the option to evict them.
For raising a complaint?
Yeah, because they do, because we have legislation governing the private rented sector which says that that's acceptable.
Did you have anything?
I just wouldn't agree with that, but there you
go. Okay. Okay. And so the government's proposals to ensure tenants have access to alternative redress schemes, do you think that would be helpful given the comments that you've just made?
I think it is a welcome move, but I really wouldn't want to make any sort of bold claims about how effective it's going to be.
Do you think it's sufficient? Or?
I don't think it's sufficient because I think, again, it's the problem Julie was talking about you can't focus in on a particular problem and then very narrowly try and address it. You have to be looking at this in the main, and I think when you look at it in the main, Shelter would certainly argue that one of the things you begin to have to look at is the fundamental kind of power imbalance in the private rental sector, and do people have the stability and do they have the incomes which allow them to maintain a decent home for themselves.
And so with this power imbalance, you don't think that these things would be sufficient, these redresses that government?
Not across the sector as a whole. I think they're useful for some tenants, but they're not necessarily going to reach into all corners.
Okay, thank you.
Chairman, thank you. Can I turn to licensing? And I'm thinking here principally about selective licensing, but I'm sure we'll get into HMO licensing as well. How effective do you feel are licensing schemes, particularly to improve the quality of people's homes?
I think it's really important to understand whether and how far licensing schemes have a beneficial effect on quality. It's a really important question, and it's something that we've been looking at in a lot of detail, and I've still to find evidence that links those two things in a way that's robust enough for us to be confident about, that selective licensing leads to. This is not to say that over a long period of time there might be improvement. I think one of the difficulties that a lot of local authorities have in approaching particularly a borough-wide licensing scheme is that a lot of local authorities are absolutely in the morass of just simply collecting information on what their sector looks like. So they're in the morass of collecting information on who is a landlord in their borough, and then at some stage they might be able to move on to thinking about more effective enforcement. But this task of counting and quantifying and deciding who's in the sector is a hugely, hugely important task. But I'm not sure the local authorities are distracted by it and thinking about how best to effect property improvement in the sector. I think the two are associated, but it's going to take an awful lot of time for that licensing regime to result in improvements in property quality, particularly. It does seem to be effective in taking some kinds of problematic landlord out of the market, and absolutely that's quite interesting. But we've got evidence from other local authorities and landlords as well, so there's lots of mixed sort of messages coming, that actually a lot of this is beginning to look like a bureaucratic exercise of making lists of people, charging amounts of money, receiving those monies and just maintaining lists. And maintaining a list isn't the point of the licensing exercise. The point of the exercise is to improve property quality.
So from the evidence you've got, at this stage, there's no link between the issue of the licensing scheme and a demonstrable improvement in the quality of accommodation. Clearly changes in terms of the landlord, but in terms of the property, no evidence at this stage.
No, I think it's interesting. We were trying to sort of assess how many properties have been visited as a consequence of licensing. You would hope that licenses would only be issued if a property was meeting certain quality standards, but the legislation is that property has to be visited within a 5-year period. I think we looked at 2013-14, and we estimate around 2% of PRS property had probably been inspected, possibly, which is very, very low, thinking that these regimes have been in place for quite a long period of time. So the actual inspections activity is really low compared to the size of the sector.
I think I think licensing does two useful things. One, it does help to identify those worst offenders, because I think most local authorities, particularly if they've got a large PRS, they will know who the real worst offenders are in their area. So it can help with that problem, but it can also help with that sort of culture change and expectation. The problem is that it's inherently piecemeal, because you're only imposing that on landlords who are in a particular postcode. I do think there is something interesting and sort of grounds for optimism if you look at Newham, where their borough-wide licensing scheme has been accompanied by a huge number of enforcement notices. So that does suggest that if you move beyond just using the licensing scheme to compile a list of your landlords and actually start using it to really drive about an increase in standards, that it can be effective as the kind of first tool for identifying where you need to look. But I think certainly it would be kind of naive to think that just by proposing a scheme that's sort of job done. It does have to be part of a really dedicated, well-resourced strategic focus on conditions.
So the game for you is the increase in the number of prosecutions?
Yes, yeah. If you think of licensing as a way to identify who your landlords are and begin a process of enforcement around the worst offenders, rather than just as a sort of head count of who's letting properties in that area.
Well, yes, at the very sharp end, in the context of possession proceedings, not having a licence for a property that requires one does mean that a Section 21 notice can't be used now. And certainly Bow County Court, which is one of the courts in Newham, which has recently been closed down, was quite aggressive in ensuring that all of its district judges and deputy district judges who were hearing possession claims would actually press that point, even if the tenant turned up unrepresented, even if the tenant didn't actually turn up to a hearing at all. And there were landlords who were coming to uncontested hearings finding they were not getting possession orders because they couldn't satisfy the court that they had a licence for the property. I suspect in quantitative terms very few tenants actually benefit from that provision, but it is a very effective means of conveying to some landlords that if they haven't complied with the licensing regime, they will not get possession of their property back.
I mean, it's intriguing in the sense that the number of prosecutions in Newham is large, indeed it's as much as most of the other boroughs. Why is it therefore in London, for example, that none of the other boroughs have gone down that path, or very few have actually taken that route?
I think the judicial review which was issued against Newham did have a massive chilling effect, where other boroughs were just nervous to pursue the same borough-wide approach. And it was only at the end of last year when Newham's scheme was renewed. And interesting, actually, the Secretary of State stopped short of renewing it as a borough-wide scheme, and they had to remove the Olympic Park, which there are good grounds for doing if you look at the kind of nature of properties in Olympic Park, but it does mean it stops the precedent being set about borough-wide selective licensing being okay. But I mean, I think certainly if you look at what local authorities have done in recent years, that chilling effect means we can't really judge how much enthusiasm they have. I know Redbridge were keen to pursue their own borough-wide approach, but again were deterred by the sort of legal pitfalls.
But the scheme started in 2013.
Yes, but it was then judicially reviewed and they had to apply to the Secretary of State for permission to renew it, and that was only granted at the end of last year.
I think a second issue which very rarely gets talked about is we don't really understand the economics of the licensing framework in terms of how much it does cost a local authority to pursue that and whether they can see measurable benefits as a consequence. And I think some local authorities might have considered those issues and thinking, actually, we don't have the resources to do it, and that's a reason not to do it. None of these activities have been accompanied by an economic evaluation of how much it costs to implement and what results have come out of it. And I think it's very difficult for a local authority to think we should do the same without understanding how much it cost and what results came out that were kind of robustly connected to the activity.
I was looking to see whether there was an independent assessment. So Newham itself hasn't done an assessment of the costs and the revenue, as it were, from this process in order to work out what the net cost is to it as a borough?
It may have done, but it's not publicly available.
They've not published it?
Well, I'm saying they may have done, but I haven't seen anything publicly available.
Okay, yes, okay, thank you. And perhaps just looking beyond that then, are there other ways that local authorities can solve the problems about the quality of accommodation, about the nature of the landlord, rather than licensing the schemes? I mean, one of the things that seems to come from certainly the evidence you've given us and some of the written evidence is the big variance in the level and ability of enforcement, very often between neighbouring authorities with similar demographic situations. Is enforcement actually the issue here, whether it's resourcing it or whether it's actually looking at comparable performance between authorities to get everyone to raise their game? Is that a critical issue?
I think we can't presume that every local authority thinks about the private rented sector in the same way. Some local authorities have a particular view of the private rented sector in terms of this is something that we need to work with, now work with it. Some local authorities don't want to work with the private rented sector. I'm not saying either of those approaches is right or wrong. Some local authorities have two distinct and different views of the private rented sector simultaneously. So they might think quality is an issue in the private rented sector, but our homelessness teams are still placing people in those properties, and unless we had those properties available, we wouldn't be able to fulfil our homelessness duties. So local authorities are remarkably conflicted about the private rented sector. I would say that very few local authorities have got joined up strategic understanding of what they want from the private rented sector that goes across tenancy relations officers, homelessness officers, environmental health officers. They don't join up policy to think about what they want the sector to do in their area, and I think that's a really big problem.
Good, thank you.
2 points on selective licensing. When we looked at it as a committee, the previous inquiry, there were two issues that caused concern. One was the restrictive nature of the criteria for having a selective licensing scheme. Now, I understand that's now been broadened. Was that a good move by the government? And secondly, the bureaucratic nature of the process of actually going about setting up a selective licensing scheme. Is that still a problem that we ought to be concerned about?
I think in terms of broadening the criteria, it was certainly something we welcomed. I think it is notable that when you look at where selective licensing came from, it does seem to be coming from a very different era of the private rented sector. It conjures up an image of antisocial behaviour, low demand, and sort of areas in decline, whereas what we often see now is the areas with the biggest problems in the private rented sector, it's actually high demand driving it, because landlords know that they have a sort of captive market. In terms of bureaucracy, I certainly wouldn't feel confident in talking about the bureaucratic demands on local authorities. I would say, though, that that's always something which has struck us as an attraction of borough-wide schemes, because it seems, to our point of view, infinitely more simple to have a borough-wide scheme, which you know if you operate in Morecambe Forest, you are subject to it, rather than having to work out whether you fall under a particular selective licensing scheme, which may cover a discrete neighbourhood. And potentially, if you're a landlord who works across several postcodes and several boroughs, then you're dealing with lots of schemes as opposed to maybe just one or two.
I think it's very difficult to, I'll always say this, academic to judge because the evidence is quite scanty. I think for a local authority thinking, you know what, actually, these 3 streets are where it's at in terms of HMOs, in terms of poor landlordism, this is where the problem is. There is no point in licensing the whole of the borough and spending lots of time chasing landlords who, for the most part, aren't problematic, when it's this part of the sector that's problematic. Because when somebody then comes to make a complaint about their landlord, the HOs are too busy chasing compliant landlords to be able to deal with it. So I think there's advantages and disadvantages to different approaches. I think certainly it's welcome that we've got a relaxation of the restrictions around what constitutes the reasons to pursue it. But I think, and local authorities have to pass through a number of different hoops before they're able to sort of start introducing something. And I think that's difficult. I think for a lot of local authorities might think the hurdles are too great for them to think about what they want to implement in their borough. And maybe local authorities should be given greater powers to decide what's good for their borough. And what is the problem in their borough, rather than having to deal with national requirements of what is deemed to be problematic.
Okay. Mary, how do you get a follow-up point? You're okay. Okay. Liz.
Okay, I'd like to ask about other approaches local authorities are taking to promote the private rented sector, and what are some of the most effective approaches that local authorities have taken to support the provision of high quality, affordable private rented accommodation in the local areas?
I think one of the big challenges is that affordable isn't really within their gift. With the divergence between wages and rents, an increasing proportion of the private rented sector is reliant on local housing allowance to make the rent affordable, and that is of course a matter for central government rather than local authorities. And I think certainly that is a tension that we see as being central actually to a lot of the problems where local authorities have. It limits their ability to run effective PRS access schemes because they can offer all the incentives and help with deposits in the world, but if a landlord knows the tenant can't afford the rent on an ongoing basis, they're not going to take part. And it does undermine efforts to improve standards in the sector. If we think back to the rationale for the local housing allowance cuts, it was very openly stated that it was about ensuring that people on housing benefit were restricted to the bottom end of the market. And we can't be surprised if the bottom end of the market doesn't look like the top end of the market.
I think Kate's absolutely right. I think this isn't in the gift of local authorities. I think the local authorities' actions in working with the private rented sector are entirely stymied by the freeze in local housing allowance rates at the moment, and that's proving hugely problematic. And I think looking towards the Homelessness Reduction Act, I wonder how many local authorities will be able to effectively use that legislation if the freeze continues, because local authorities, I think, will be finding that landlords won't necessarily be willing to be working in that part of the market.
Right. So it sounds like you're saying there's a direct correlation between the level of local housing allowance and the quality of housing, is that right?
Not necessarily the quality of housing, it's more really about the willingness of landlords to take tenants that are wholly or partly reliant on local housing allowance and the rates of those payments. I keep saying we don't understand the economics of things. We don't understand the economics of the bottom end of the market and whether and how far any landlord with the best intentions can take a property and let it to somebody reliant on local housing allowance and make that work. We don't know that that's the case. And I think unless we start looking at that, we can't expect the bottom end of the private rented sector to be picking up this demand.
Right. So the two are inextricably linked, you think?
Absolutely.
Yeah. Okay. So do you think there is more that local authorities could do to support and encourage the provision of private rented accommodation for people on lower incomes? Do they need new powers or funding? I guess with what you've just said, the answer to the second bit is yes. Are there other things?
I mean, I'm sure around the margins there are some useful things that they could be doing. I was at a very interesting conference of local authority officers before Christmas, and there were some basics that some local authorities weren't getting right. You know, if you were a landlord, you wanted to let your property through them, you couldn't find their number, you didn't get your emails replied to, you didn't have consistent sort of communication. So there's that basic kind of customer service element, which I think not all local authorities can be claiming to be on top of. But as I say, the basic consideration for landlords comes down to, will I get the rent covered, and will the rent I receive be comparable to what I could receive if I was going through the private market and wasn't involved in the local authority? And if the answer to that is no, then all the hotlines and rapid response emails in the world aren't going to counteract that market pressure.
So it's tinkering around the edges.
I think for some markets there is a positive where the local housing allowance rates are very close to the market rates, then that's fine, that's good, because local authorities can actively work with landlords to improve property quality. But in other areas where there's a big disparity and shortfall between the two, it's very difficult. And actually, as I've argued before, local authorities run the risk of introducing perverse incentives for landlords to hold out for an incentive to let to somebody, and it skews that part of the market, and it's something I think that is a particular concern as the Homelessness Reduction Act comes, that a lot of local authorities are looking to what kind of incentives do we need to put in place to work with that part of the market. And landlords will increasingly expect some kind of incentivisation to work with at the bottom end.
Yeah, I think that's completely right, and I think on that we also have to be keeping a very close eye on the sort of cross-borough competition that might emerge, because certainly it's already seen in temporary accommodation where one borough may make the decision that accommodation is just not up to scratch and they will not work with those landlords. If a neighbouring borough comes in and decides that they're happy to work with them, then all of your efforts to raise standards are just instantly undermined. And I think with the presumption of a far greater role for the private rented sector, I think we have to be looking really carefully at how we make sure that local authority competition doesn't drive a kind of race to the bottom.
Okay, we're speaking in generalities, but I note that you referred to, how far away the local housing allowance amount is from in one area compared to another. Is there anything you'd like to say about that? Are there any hot spots where that's a particular issue?
If I could chip in here. One of the perverse consequences, I think, of this is that there are many London authorities that are building really quite good relationships with the private rented sector in places like Walsall and Birmingham and even further north, because they simply cannot afford to house homeless people in their own areas, and they're shipping them very long distances away. A great deal of litigation in relation to the homelessness legislation is in respect of what are called out-of-area placements. But it does seem a rather peculiar scenario, for example, that Westminster in particular employs housing officers who are effectively based in Walsall in order to find properties in the Walsall private rented sector to house people who are being decanted out of Westminster. And that may cause some tension as well with local authorities in the areas which are being affected. But it is a very odd scenario that you may find more aggressive outreach work towards the private rented sector from London authorities hundreds of miles from London than actually in London itself.
And a massive implication for the residents themselves.
Well, yes, it would be very disruptive, but also has ramifications for the private rented market in Walsall, which is now being in effect invaded by people from the south.
Okay. Andrew.
Yeah, so we talked about the local authority angle and some of the sort of, as you said, tinkering around the edges. But what about the government's announcement that it will bring forward new incentives for landlords who are doing the right thing? Trying to think a bit more sort of broadly or wildly even. How could landlords be incentivised to improve the quality of the accommodation they provide and improve security for their tenants? So not just necessarily, some of the local housing provision and funding, but just, the really broader picture.
I mean, I think if we're looking at specifically the housing benefit submarket, one key bone of contention for landlords is around the issue of whether payments are made direct to the tenant or to themselves as the landlord. And it's been policy of governments of all parties in recent years to put the emphasis on payments to the tenant for very sound reasons around sort of, not having a big distinction between being in benefits and being in work and issues around responsibility. But that does seem to have made landlords quite nervous, and that anxiety seems to be being heightened ahead of universal credit coming in. So one tool that I've always been struck by as potentially underused is what more we could do around the sort of quid pro quo of a guaranteed landlord payment in return for meeting certain conditions. So, for example, you get the guaranteed landlord payment direct to you if you take a family on a private rented sector office with a statutory homeless on a 3-year tenancy, for example. That sort of works with the local authority, potentially works with the landlord, and it's giving them that kind of stability. So I think there's kind of more that could be explored around the sort of financial security angle.
I think the notion that you need to incentivise landlords to do particular things, you need to unpick that. There's a difference between incentivising a landlord to offer a longer tenancy, incentivising a landlord to offer better quality. They're two slightly different policy issues. Most landlords really want to let longer tenancies. And the reason why tenancies fail are not really about the AST, they're about other things, they're about affordability issues. So with all the will in the world, you can place people in a 3-year tenancy, but if they can't afford the rent, what is the point? So issues about incentives, they tend to be overly generalised, rather blunt, and not really address what the problem is. What you want is a better private rented sector. Incentivisation tends to be a rather blunt instrument. And going back to the beginning comments that we made, parts of the market are reasonably professionalised, some parts of the market let through letting agents that operate very well. All of those things, do you really want to incentivise landlords who are already offering reasonable quality accommodation and longer term tenancies, because that's what the tenants are sort of moving into? So you've really got to think about where is the problem and how do we deal specifically with the part of the market that's problematic, not thinking about throwing incentives at the private rented sector like the entire sector is a problem.
Does this comment then strike you as something of a slogan?
I think we tend to think we need more regulation of the private rented sector. It's not helpful. We need to think about what regulation we have, why it's not working, where it is working. We need to think about what is good about what we're doing and do more of that, rather than thinking that we need to add another layer on top of what we're already doing.
Good answer. Yeah.
Yes, well, moving from encouraging landlords to do the right thing to the bad landlords that are a really serious problem. Namely, particularly in London, there are specific problems of family homes being subdivided into very small bed sets and then let out in what we call so-called lockdown properties. And also the other challenge is beds and sheds, which are a real problem right across London. What should be done about these particular problems?
I mean, I think, first of all, you do have to appreciate where they're coming from. You know, these are all symptoms of a market where you have a section of the market that has huge affordability problems, and particularly across London, increasing demand. And if you didn't have that, you wouldn't have tenants willing to accept beds and sheds and willing to accept these very small conversions. I think I still haven't seen very reliable data on the kind of issue of lockdown properties and how many properties we are talking about. I think one issue that possibly warrants expansion, although there are unintended consequences to think through, is the option of whether you could have a studio local housing allowance rate between the shared and the one bedroom. The challenge is that landlords don't have to do an awful lot to sort of pull themselves over the bar of being considered self-contained. Sometimes it's just putting a microwave into the room, for example. And I think if you could have a way to distinguish between what's a genuine one-bedroom property and what's a studio, that might change some of the financial incentives. But I mean, it's sort of related to the question earlier. I'm not sure we can deal with the symptoms of a pressure which is of a market which is overheated and has serious affordability problems. I think we have to, if we don't like what we see, then you have to sort of start from unpicking the market itself rather than just the sort of hotspots.
Well, you've mentioned earlier in your evidence the particular challenge. I think Ms. Rudd, you mentioned the issues over the different challenges from different council departments, for example. And one of the challenges that I think is certainly true is for a local authority that inspects these properties, uncovers the problem, that suddenly that group of people may well become homeless and therefore potentially liable to be rehoused by the local authority. Is this a conflicting problem?
I mean, I think it potentially is. I think if you look at the demographics of who are in the properties, a lot of them won't be in priority need. So in some respects to the local authority, they don't have that risk. But I think local authorities are acutely aware that sometimes it can be the case between choosing to raise standards and choosing to make people homeless, whether it then falls under their kind of responsibility or not. And that will be a tension for them. I think one of the things that makes Newham interesting is they have sort of decided that they're very comfortable with those unintended consequences, whereas I think other local authorities are a lot more anxious about seeing kind of increased homelessness.
I mean, the other issue is that the GLA published just before Christmas a detailed report on the problem of beds and sheds across London. Have any of you had a chance to review that and give a view on it? Because clearly that itemises literally thousands of properties where there's no council tax being collected, huge amounts of rent being collected, and people living in, quite frankly, outrageous conditions. And I can accept the fact that the market's overheated, but the issue is one of, here are people that are being exploited, and I don't think any of us would condone that position.
No, I mean, I personally haven't had a chance to review it yet. I think when I do, certainly one thing I will be looking for is whether they've looked at whether those households who are being exploited are also the same households who are subject to the right to rent restriction. Because I do think we have to accept that, you know, the very obvious unintended consequence of saying that the mainstream market isn't accessible to people is that you will then get a black market opening up.
I think that's a really fair comment, is thinking about who are the tenants. And I think a lot of the enforcement activity tends to overlook the consequences for the tenant. And I think it's something that we really need to be closely aware of. And I think local authorities, environmental health officers, it's very rare that they will go with somebody who's then got the interest of the tenant at heart and thinking about what is going to happen to the tenant in these circumstances. I mean, in some instances, we asked about why people don't complain. Sometimes they might just, what is going to happen to me? If it's the case that somebody will come in and say this property isn't habitable, what's going to happen then? The local authority doesn't have a strong track record in demonstrating that they're going to help that person move to a habitable property.
I mean, there are frequent examples that I could quote from my local authority and neighbouring local authorities where literally beds are being rented for 8 hours a day and multiple people are then sharing that bedroom almost on a cyclical basis. That used to be a problem in New York, for example, as a real problem. It's now a problem in London. Have you had a chance to take a view on that particular issue, because clearly that's something that landlords are either involved in directly or indirectly through someone having a tenancy and then subletting, possibly illegally.
I think you're right about the subletting issue. I think it's something that we've not really got a very firm handle on, the number of the number of landlords letting in good faith and then finding the properties being subdivided by a criminal tenant. And it's something that we really need to sort of try and get a grasp on. Certainly, it's really problematic, that part of the market. Some tenants are making economic decisions that that's how they're going to live for a proportion of their lives, and then they might move back to or move on to somewhere else, and they've done that just for a period of time. I'm not saying that all tenants are like that by any stretch of the imagination, but I think at the bottom was what Kate's saying, that some people are willing to take that. They're willing to take that for a lack of an alternative, and that's the heart of the issue, is the lack of an alternative.
Okay, all right, thank you.
Just coming back to lockdown properties, recognising we want to try and sort out the housing market in a wider sense, but that's going to take time. In the meantime, some landlords, almost the criminal element in some cases, are simply taking the taxpayer for a ride, aren't they, with lockdown properties? I mean, that's what they're doing. They're milking the public funds and not providing proper accommodation. So apart from the issue of having a different element of housing benefit for studios, is there anything else we should be doing to stop this practice?
I think a lot of the issues sit around definitions, and it's clear that this practice can take place because of the fact that the law doesn't marry together particularly well, and it's possible to find these little sort of ways through the legislation. And I think one of the messages that comes out of that is that the legislation is poorly framed to deal with landlords who can decide to circumvent them one way or another by being quite clever in the way
so
in which
it's the case again, different bits of legislation
not necessarily matching up.
Yeah.
So a local authority officer who might be visiting that property might not necessarily find, actually, you know what, it is quite small, but the property is containing the things it's supposed to contain. So, okay, the rent's really high, but I'm not looking at the rent when I'm assessing this property. I'm looking at whether it's suitable for one person to live in. Yeah. So I think, a number of things might say this seems to be wrong, but actually pinning down the legislation that says this is why it's wrong is quite problematic.
Yeah, and it's as we so often talked about, it's the crossover of DWP as well, where the policy intention behind local housing allowance is that it's very simple. You have a very large broad rental market area and then a going rate for properties within that. And even before lockdown properties, you have particular problems where, for example, Jaywick, which is a very deprived area, falls into a much more affluent BRMA. And I'm aware that the local authority there have previously raised it with the Department for Work and Pensions that they would like some sort of power to intervene on a case-by-case basis. And I think ministers and officials have been very reluctant to sort of compromise the simplicity of local housing allowance for that intervention. And I certainly wouldn't want to kind of speculate here as to which way it should fall, but I think that is potentially an area that merits kind of further evidence.
Okay, thank you for that. Now we want to move on now to the pre-legislative scrutiny of the draft tenant fees bill, which is the second part of our considerations today, and look specifically now at the proposals in the draft bill. Liz.
Yeah. Okay. So the government's stated objective for the bill is to deliver a fairer, more competitive and more affordable lettings market where tenants have greater clarity and control over what they will pay and where the landlord is the primary customer of the letting agent. Do the provisions of the draft bill enable this objective to be achieved?
I think broadly we would say it does, and there are certainly objectives that we strongly welcome. I think there are two areas of potential concern that we'd probably like to focus on today. The first is around default fees and whether the clause is specific enough and provides enough safeguards. And I think our central point is that it's quite problematic as it currently stands. And the second is something we didn't raise in our written evidence but are subsequently concerned about, which is the risk that the bill as crafted allows for exit fees, which could potentially cover a wide range of services from kind of cleaning to checkout to a generic exit fee.
Okay.
Well, I think in principle, or in broad terms, the bill is likely to achieve that objective. And speaking as a lawyer, both a practitioner and an academic, I do have a number of detailed concerns about the way the bill is drafted at the moment and the implications that it might have. I don't know if it's helpful if I address them seriatim. The thing that I think most concerns me is the enforcement mechanism, which is laid out from Clause 7 onwards. So the draft bill, for example, envisages an initial fine to be levied by a local authority, which could be anywhere between £1 and £5,000. £5,000 does seem a potentially disproportionately large amount in relation to what may only be a few £100s in terms of prohibited payment. And I'm curious why there doesn't seem to be any effort to link the fine strategy here with the damages provisions in the tenancy deposit scheme, which fix a ceiling at 3 times the amount of the deposit that's been unlawfully charged. I'd be concerned also that the range is going to lead to very wide discrepancies, not just between local authorities, but possibly within them, even on a month-by-month basis. So that you may find yourself with 2 landlords in very similar situations, one of whom is being fined £500, one of whom is being fined £5,000. There does not seem to be in the bill itself, nor in the explanatory notes, although it may feature in the subsequent guidance, any governmental attempt to structure local authorities' discretion in relation to the size of fine that they charge. And I think that's a serious omission. It becomes a more serious omission, in my view, because of the way Clause 7 interacts with Clause 9, Clause 9 being the criminal offence provision. And if one reads back from Clause 9 into Clause 7, one finds that the fine can now go up to as much as £30,000. I have a specific drafting concern about this. If one looks at Clause 7.3, it appears the local authority can raise its fine to £30,000 if it is satisfied beyond reasonable doubt that the landlord or the agent has committed an offence under Clause 9. That, I must say, seems to me a quite extraordinary proposition, because it appears to be empowering the local authority itself to decide that someone has committed an offence, even if the person has not been brought before a magistrate's court and actually convicted. And if that is the way that the bill is interpreted, and that's it, it's a literal reading, I think they're beginning great difficulties reconciling that with Article 6 of Schedule 1 of the Human Rights Act, because you're effectively turning the local authority into a magistrate's court with a very substantial punitive jurisdiction. And although strictly speaking, of course, there's a civil penalty, I'm certainly sure the European Court of Human Rights would take the view it's analogous to a criminal one. It is a punitive measure. This then goes on, forgive me if I'm being too lawyerly here, into the appeal provisions that we find in paragraph 6 of Schedule 3 of the draft bill. The jurisdiction is given to the first-tier tribunal, but if one looks at paragraph 2, Schedule 3, paragraph 6, subsection 2, Schedule 3, it's not clear to me what the jurisdiction of the first-tier tribunal is. So in section 2b, this is at page 20 to 21 of the draft bill, there seemed to be an allusion to orthodox judicial review grounds. So an appeal can be brought on an error of law. But also 2a seems to empower the tribunal to decide all questions of fact, which makes it sound like a primary decision maker, not exercising a judicial review jurisdiction. And then in 2C and D, we find the term reasonable being used, both in relation to the level of the fine and also into the decision to make a fine at all in the first place. Now, those are terms which lawyers will tell you could mean either Wednesbury unreasonable in an administrative law sense, which means the tribunal's jurisdiction would be very light touch indeed, or it could mean reasonable in the possession proceedings sense, which means the tribunal determines every question of fact and law as if it were the primary decision maker. So it seems to me that that's something which really ought to be clarified in terms of what the legislative intention here is. What is the tribunal's role as a de novo primary decision maker, or as in effect a judicial review forum? And presumably if one finds landlords who are being fined £5,000 or even £30,000, that question is going to be a very live one, because the intensity of the tribunal's jurisdiction is going to have a very large bearing on the fine, if any, with which a landlord eventually leaves this process. Related to that, again, I'm happy to pause if that would be helpful.
Say, on the issue of the size of the fine, I do think we have to remember that what the bill is trying to do is disrupt an industry. And I think there is a risk that if the fine is not meaningful, then given what we know about lack of enforcement and given what we know about tenants often not being aware of their rights and able to exercise their rights, you do run the risk that with small fines, letting agents will simply price that in as the price of doing business. So you do need something which acts as a deterrent. And I'd say as well that the comparison to the deposit protection scheme, again, slightly ignores the differences between landlords who may only have one or two properties and letting agents who I think we can assume will have multiple tenants all subject to the same fee regime. So just charging a fine of 3 times the fee will potentially ignore the size of the sort of pool of consumers who have been affected by the unfair fees, and again won't act as a sufficient deterrent, would be our concern.
Okay, so one of the questions was about making whether this will deliver a fairer, more competitive and more affordable lettings market. With the if those things were looked at that you've raised again, clearly you've raised some very technical legal issues, but the principle of the thing, if you were to be able to look at the issues that you've mentioned, would that make it more effective? Or what could be done to make it more effective to resolve those problems?
I think there's, I don't have lawyerly comments on it. I think it's interesting to look at the contextual information that attaches to this, and the word safe is used 2 or 3 times, but the word safe doesn't really appear necessarily in the drafting. I think if I wanted to sort of seek transparency and a more competitive sector, I think tenants should be given clear indications of the quality of the property that they're looking to, that they're being offered, that they can then compare across different qualities in terms of property. I think that's really quite important. I think that in terms of the impact sort of assessment that needs to be attached to this at the moment, we are not in a very good position to be able to judge the impact across the board on what this kind of activity is going to do in terms of costs and where the costs are going to sort of fall necessarily, and how it's going to impact on that in terms of practice. I'm not saying that necessarily the rents might go up as a consequence. I'm always more concerned that actually the quality will go down rather than rents going up, because I think markets are such that a rental level will be maintained, but actually the quality of the property might decline. The landlord's willingness to attend to repairs might go down if the letting agent fees go up. So these are the issues I think we need to sort of think about. So
for you it's a link to safety and quality?
I think again, it's a piece of legislation that's decided there's a particular issue and that's targeted that issue in a very, very piecemeal way. And on one level, yes, that's an issue that needs to be dealt with, but it's being dealt with in an unstrategic way. We're not asking what we want. We're not asking what we want letting agents to be doing in the market. What do we want letting agents to do? We're just pinpointing what we don't like them doing, without really necessarily saying, actually, what we want letting agents to be doing is to effectively create bits of the market that we're quite confident about, that they're letting at good quality, the rents go up in a reasonable, staged way where everybody knows what's going on. These are the things we want letting agents to be doing, to be professionalising on behalf of landlords. But the legislation that comes through is very bitty, and it's not necessarily addressing that wider kind of strategy.
I think, given though the narrow confines of the Act itself, our view is that we do think it goes a long way towards improving competition in the sector. I think it has always been a source of concern for us that the agent chooses the landlord chooses the agent to market their property, and tenants overwhelmingly shop around for the properties. So they effectively have a captive market then of who the landlord has appointed as the agent, with very little ability to say, I really like the property, the conditions work for me, the rent works for me, but I've had bad experiences with X agent before. They can't do that. If you want to do that, you have to effectively walk away from what otherwise might be a perfect home. And certainly when we're surveyed landlords before, an awful lot of them are actually unaware that agents were often charging both them and the tenant fees for often the same service, which makes them nervous because what they don't know is it fair, is it double charging, or is it actually splitting the cost, who is the agent actually working for. And we have always been clear that if you look at the actual relationship, the agent is working on behalf of the landlord. And I think having that clarified in terms of the fee arrangements will be incredibly welcome. And it will also mean that you have much clearer pricing in terms of what's quoted to the landlords, which we would hope overall would reduce costs. Because at the moment, agents are strongly incentivised to make the most attractive offer to the landlord, who is the active consumer, knowing full well that they can pass it on to the tenant, who is far more passive in the situation. If you have all of those cost concentration on the landlord side, then what you have then is a very active, empowered consumer who can really question, why is it £700 for a tenancy fee, whereas tenants sort of just have to accept it because the alternative is losing out on property.
Fiona. Thank you. Julie, just going back, you mentioned about the impact assessment previously. So are you concerned that a full impact assessment has not been published?
I would be very interested to see what is contained within the impact assessment, certainly.
Okay. Is that the same thing?
I think we would always want to see the impact assessment. I think we are personally reassured by a lot of the evidence that has come out of Scotland after they clarified the ban on fees north of the border, which doesn't give cause for concern around what's happened to rents, and also points to some areas where you can tighten up enforcement and awareness to ensure that the legislation is as effective as possible here. Namely, the simpler and more transparent it is, the more likely it is tenants will be able to self-enforce by just knowing and advocating for their rights.
So it's prudent that something should be published?
I think it would be complacent of us to say you should have legislation without having an impact assessment, but certainly it's not been a cause for concern that it hasn't been available to date.
I couldn't add to that, I think.
Thank you.
Okay.
Yeah.
You spoke earlier about the changing demographics in tenants. So what sort of tenants in the private sector do you think would benefit most from the draft bill?
I think we're looking at, I would presume, the middle part of the market where these fees are accepted and understood to be part of the transaction that you would have. It wouldn't necessarily be benefiting people very much at the bottom end of the market because, for the most part, they wouldn't be looking to make those kinds of arrangements, I think. I think the thing about the middle part is that you want to see an effective market where people are making those choices. And I think if consumers are fully able to shop because they have all the information available to them, then the response of the market will be to improve what they have to offer and to improve the transparency of what they have to offer, you would hope. So it's the middle part of the market, I think it'll have the most impact.
The only thing I would add to that is when we surveyed private tenants and looked at their incomes versus the average fees they were paying, it was actually lower income tenants were paying higher fees, which was certainly not what we were expecting because we assumed it would work as you suggested. So I think we can be kind of cautiously optimistic that it will have broader benefits than just that sort of very mobile mid-market. There does seem to be some particular problems around the fees charged at the lower end, and what that might be is because the additional costs that are incurred around issues such as guarantors and additional referencing and that kind of thing.
I think on the flip side then, I mean, who do you think there'll be at risk to a cohort of people that do rent at the moment, so low-income families or those that they deem at risk with pets or smokers, or just because of the, again, decisions from letting agents, if you like?
I think certainly the area we will be looking at most carefully is, are there any adverse consequences around referencing, and do you find that when agents and landlords are bearing the full cost of referencing, are they kind of turning away some potential tenants for superficial reasons without actually going to the expense of running them through proper referencing, and is that leading to inadvertent discrimination? I'm not sort of predicting that will happen, but certainly if we were looking at areas to look out for, that would be on our list.
I think I'm concerned, I'm going back to the impact assessment. We don't really, I always keep saying this, but we don't really understand the letting agents industry particularly well in terms of the range of particular types of letting agents that are out there. The very high-end franchised letting agents that operate quite professionally, some estate agents who might also be doing letting on the side, but also some landlords who are letting property on behalf of somebody else on quite an informal kind of basis. So actually the impacts are going to spread across that kind of activity, and that's why there is concern to see these sort of impact assessment, because you would hope that that demonstrates a really good understanding of how the industry works. Because unless we understand how the industry works, we won't really understand what the impact's going to be.
Yeah. I mean, I think it is better that we're kind of operating in the dark a lot, because certainly what we see from clients would lead me to question even that assumption that the high-end, the sort of more professional big brands are operating in a professional way.
Yeah, I agree.
You know, we've come across supporters who were using kind of established names as agents, but were still being asked to hand over money in a supermarket car park as a holding deposit. That isn't what professional looks like.
Exactly. I think exactly that.
And Julie, you mentioned before, so we got your views with regards to rent increases. If this legislation went through, the proposed legislation. So you're saying you're not confident that will happen. You think it'll be.
I don't. Going back to this, we don't understand the economics of letting agents as an industry. We don't understand where the fees go. There's a presumption that everybody's going to charge as much as they can get away with. And
what happened in Scotland though? Because obviously they did that. Was there an increase in rent in Scotland or no?
But we don't know how the economic basis of those businesses might have changed as a consequence, and where those letting fees, where that might have disappeared somewhere else within the business model. Because we don't understand what the business models look like, we don't understand what the impact might be, and the costs might be somewhere else within that business model, but we don't know where. And actually it might take a while for it to become available and known to us that actually that's where this is where it's happening. So I think it's naive to say we can take some money out of this and nobody's going to feel it, and nothing's going to happen, everything's going to be fine. But what do these models look like, and how are they accommodating that decrease in income? Because they've got to accommodate it one way or another. And we've got to understand how they're accommodating it, I think. And it might be around things like we don't do as many inspections of the property as we might have done in the past also. So there's a cut in service rather than a cut in rent. And I think that's quite an interesting thing to think about, that they might not be training their staff in a way that you would want them to. So all of these other things could be a consequence of these fees going down that we might not see immediately, but actually in the long run might have an impact on how that market works as a good professional market.
Yes, it's a supplementary, and I think it's probably going to be going on to the next part of it about the increasing costs, and it will be on that.
So on the
Sorry.
It's okay?
Yeah, okay.
Yeah, no, I'm fine. So the risk that there'll be less available housing in the private rented sector as well, so it's just going back to that risk. As a result of the potential increase in landlords' costs, again pushing up rents further. So, you know, is that something that you've done any assessment on?
It's not a risk that we really recognise, I have to say. I mean, it doesn't appear to have happened in Scotland, and also agents are voluntary for landlords. So what is probably more plausible is that landlords just decide that they'll self-manage. Whether that's a good thing is open to question, but then it's not a simple answer, because it also depends on your assessment of how effective letting agents actually are at raising standards. If they were a well-regulated industry with significant barriers to entry, then you'd be concerned if landlords were turning away from them and self-managing. But given that there are very low barriers to entry, it's harder to be concerned at the notion of landlords going it alone.
Again, it's just the impact. You know, we're talking about the letting agents and we're talking about the industry, but it's the impact on the tenants that these things will have, isn't it? You know, so again, I think it comes back for me. You know, I'd be interested in the capacity, the resource of local authorities, trading standards as well, if they were enforcing this.
Yeah, I mean, as with our conversation earlier, I think that for us is the big risk, that they won't have the resources to enforce. And that's why I think simplicity is key to making this work. It's what you want to happen is tenants to have a very clear understanding of their rights and to be able to say, you should not be charging me any fees. And that's where some of the framing around default fees and the potential for exit fees makes us nervous, because it introduces that grey area where the letting agent can very confidently tell the tenant, who is not a professional, that, oh no, trust us, this is within the bounds of the legislation, knowing full well that it will be very difficult for the tenant to challenge that.
Yeah, thank you.
So the way it would operate at the moment, there'd be an upfront fee, and very often after a year's assured short hold tenancy, then there'd be maybe a continuation fee which would be lower. There seems to be the ability within the legislation for, whilst fees can't be charged, the rent could be higher, it could be spread, in other words, over the number of years, of the number of months in the year and onward. Is then the potential for that fee to be put into the rent, and let's say that the mean, the average fee would be about 240, spread over a year, an extra £20 a month on the rent. Whereas as we have it at the moment, that fee would be less in the second year. In other words, it would go down because it would be a continuation fee. It would then be, under the new scheme, perhaps be higher. So the rents going forward would be higher than they are now. Is this something that's been considered?
I think it was certainly something that we thought through a lot when we were advocating for this position. I think, as Judy says, it's very, very difficult to make predictions about what will happen to rents. I think what we would expect, as I was sort of trying to explain earlier, is you would not expect everything that is currently charged to tenants to be passed on to landlords, because I think it is very hard to make an argument when you look at the range and size of fees that are being charged across the sector. It's very difficult to see that a landlord who has the choice about whether they go with that particular agent and has the consumer power to question the fees will accept some of the costs which are being charged to tenants. Our assumption is they just won't. And certainly when you look at some of the early reactions when the ban was announced, you did hear examples of landlords demanding to know how the costs would be absorbed. So I think you'll see an overall reduction in the costs that agents are demanding, rather than just pushing everything from the tenant to the landlord. So I think that's grounds to be optimistic in the first place. Secondly, we did actually do some sort of market research of tenants about what would they prefer. And actually the overwhelming evidence was that even if there was a small risk of rents going up, they would rather have the costs spread across the tenancy rather than have those big upfront costs of moving. Because when you combine the deposit, rent in advance, the letting agent fee, plus the van, possibly cleaning, that is an awfully large sum of money to find at once, and it's much easier to manage that burden if it's spread across the tenancy. And of course, for people on a particular low income, it then becomes eligible for housing benefit potentially, rather than being something they have to find out of their own pocket, or an overstretched local authority access scheme has to pay.
So it's really what I'm saying is that it won't just be for the 1 year that the tenant is paying more. It will be a continuation of that extra payment, which in the long run is basically, the person is paying more in the rent.
But I think that is a very big assumption that the agent will be able to put on that much extra onto the rent.
But I think the points that both of you are making is that it actually becomes very opaque about how the rent is set, what costs are included in the rent, and the fact that actually those upfront costs then just become the rent. And then the issues then pertain as to, well, we needed some sort of upfront fee at the beginning. So it all starts to become a little bit confusing as to how this cost is being absorbed and what it's called and how people can define it. So it does start to become problematic.
I mean, should there be clarity about that? Should it actually be defined?
Do you find as part of the rent that this is it, and actually to say for this first initial year or first initial term that the rent is this to accommodate this cost, and then it goes down? If that's the case, that's what you would have to sort of say, rather than think it's just across the rent, across the board. And then how long is the tenancy going to last? At what point is that
is that rent?
I think that's very problematic as well when you look at what the bill is actually trying to do. I think if you were to do that explicitly, and I'll defer to you on this, but I think you'd risk actually falling foul of the legislation.
Yes, there's certainly a possibility that if the rent is artificially inflated to include a fee of that sort, then it would be regarded as a prohibited payment. At the moment, I think that's drafted quite narrowly in terms of can you identify within the period of a tenancy a period when the rent is higher than it is for the rest of the tenancy, and then there's a strong assumption that that higher figure is a way of trying to hide, not very subtly of course, a prohibited payment. If what you have is a pro rata distribution all the way across a 12-month tenancy, it's going to be very hard, I think, to make the argument that that clause as it currently stands will bite, even if you convinced the relevant local authority and then the first tier tribunal that really was what was happening.
Yeah, thanks, Chairman. Well, we've asked about self-management already, so could ask something else if I may, which is why wouldn't a simple cap as a percentage of rent be easier to do than what we're proposing in this legislation, so that you would say a lettings agent's fee could only be 50% or 100% of the monthly rent, so that it couldn't be regarded as extortionate, it would be clear and it would be capped.
I think agents have never managed to make a credible argument for what their actual costs are, is the sort of the first practical point. And the second goes back to that question of who is actually the consumer. And I think when the tenant does not have the ability to shop around and choose the agent they want to manage the property they're renting, and that power lies solely with the landlord, we would argue that it is right that the costs lie with the landlord. You know, letting agents work for landlords. They don't work for the tenants. The service is all towards the landlord. And it's hard to think of other parallels where in any other industry you would be allowed to split the costs in that way.
Okay. And given that balance of power is in place that you discuss, is there a risk that this bill will, you think, affect the smaller letting agents rather than larger ones and therefore damage competitiveness in the sector?
I mean, I can't claim to have seen their books. I think often sort of profitability doesn't quite correlate with the way you'd want. I think this is why we completely agree with Julie that actually part of what we have to be having is a conversation about what do we want from the lettings industry, because I am very struck that a lot of the sector representatives will 1 minute be talking about the risk of smaller agents going out of business, but at the same time the more professional industry bodies will talk very openly about the fact that there are a lot of people in their sector who ought to be driven out of business. So I feel we need to resolve that bigger question before we start sort of being worried about who's going to become unprofitable.
Mike?
I mean, on that point, is there a risk that it could disproportionately affect the good smaller letting agencies and actually reduce competition in the marketplace, and obviously limit the choices for tenants?
I mean, I think I don't think the choice for tenants flows, because choice for tenants comes from the properties. At the moment, the choice is the landlord's choice over who they choose to let and manage that property. And I'm not sure I've seen evidence that the huge number of agents we have at the moment is driving up standards. So I'd sort of want to know whether it's true that the proliferation of small and large and medium-sized agents is actually a good thing before I start thinking about who to safeguard. And I think it is an interesting question of why would landlords be actively choosing the worst agent to market their most valuable asset?
I think that's exactly right. I think we don't know where the value sits within the sector in terms of, like landlords, you know, the bigger landlords aren't necessarily the best landlords, the small landlords aren't necessarily the most amateurish landlords. A little bit the same with letting agents as well. So to say we've got to safeguard sort of variety across the board, it's difficult to know who's delivering what quality on what basis, I think, unless we understand that a bit better. It's hard to see where the risk is going to sit.
So you seem to be suggesting the evidence so far suggests that won't be the case.
No, I'm just saying that there's no evidence one way or another about very much of what we're talking about, to be honest.
Mark, before you go to your member, just supplementary on this as well.
Yeah. I'm aware there's no one size fits all, but you may know that there are some landlords who have multiple properties who set themselves up in addition as letting agents. So they have a separate business, which is as a letting agent for their own properties, and they can charge twice, if you like, and the tenant may miss that and may have to pay more. Is it your experience that this is happening, and do you think that this legislation will actually address that?
I've not seen data on that.
I think that, again, we're not really recognising the proportion of letting agents that are also landlords, or landlords that might also let property on behalf of somebody else on a quite an informal sort of basis. I think there's lots of informal activity going on. In terms of trying to understand what that split looks like, I think it's quite difficult to sort of arrive at. And to think about the range of services that are being offered, I think Kate was right about going back to what is being offered, what is a reasonable charge for the kind of services that are being offered, and setting that kind of framework for this is where we start our understanding, is what is it reasonable to charge people for the services that we do.
Because certainly I know we have come across examples of landlords operating that model as agents who don't charge any fees at all. And I think what no one has been able to get a handle of is how is it viable for some agents to not charge any fees to tenants when they're also their own landlord, and others charging extremely high fees.
Back on you. Okay. Just going back to the issue then of the actual framework of the legislation and whether it's going to work. I think Professor Loveland, you were talking earlier about sort of your concerns about the drafting and the legal issues. Are there any more things you want to inform the committee of, any more concerns which you think we ought to be aware of that perhaps needs further consideration if we're going to get this right and working properly?
I think there are two or three other things that I draw attention to. The first is the notion of a lead authority in clause 16. The bill seems to be entirely silent as to the criteria the Secretary of State will use in selecting which local authority is to be the lead authority. And I wonder what thought has been given to situations where you may have several authorities competing to have what may turn out to be a poison chalice. There's no ouster clause in the bill as it stands to prevent the Secretary of State's decision being subject to judicial review. So presumably it's anticipated that if he does find himself designating a lead authority and then another local authority that wants that task seeks to challenge his decision, then a judicial review should be available. If that's not the case, then there ought to be an ouster clause in the bill, making it clear that the Secretary of State's decision is final. There are arguments pro and anti in moral terms whether there should be an ouster clause, but at the moment I'm surprised by the lack of clarity in the bill, in the explanatory notes, as to what the Secretary of State should take into account when doing so. There's a very minor point arising in Clause 18, which relates to the lead authority's powers. This is in subparagraphs 3, 4 and 5, where we're in effect being told that the lead authority will enforce a breach of the legislation. I mean, it simply can't mean that. It must mean that it's going to take enforcement action against a breach of the legislation. That's just a lawyer's point. More significantly, I think, the local authority, or every local authority, has an obligation to enforce this legislation under Clause 6 as it now stands. One question that I would have liked to see addressed is what is the relationship going to be between the lead authority and another local authority which the lead authority thinks is not fulfilling its statutory responsibilities? Is the assumption that the lead authority can bring judicial review proceedings? Will it be a breach of statutory duty action? If so, is the High Court to have jurisdiction, or is it a matter that can be pursued in the county court? Those seem to me to be questions which perhaps ought to be thought about a little bit more carefully. Relatedly, and this I think could be my final point, Clause 11 of the bill is concerned with recovery of fees by the relevant person, the tenant or someone acting on his or her behalf. It appears as the bill currently stands that any application is going to be made to the county court. And I wonder why there's a division of jurisdiction between the first tier tribunal to which a landlord or agent will appeal against a fine and the recovery procedures being taken by a tenant. I'm assuming at the moment that this recovery mechanism could be part of a counterclaim to a possession action. And the reason why that is significant is that if it's done in that way, a tenant who qualifies for legal aid will receive legal aid, as the legal aid system now stands, for the counterclaim element, as well as defending the possession proceedings. But what often happens in scenarios arising under the tenancy deposit scheme in those circumstances is that a landlord very quickly gives up on the possession claim, will discontinue it, because then that means that the tenant will no longer qualify for legal aid for the counterclaim element of the legal proceedings. And I'm assuming the same thing is going to happen here. Because if there's not a possession claim, and this is a freestanding attempt at recovery, it's almost certainly going to be within the small claims court limit. So there'll be no eligibility for legal aid, which means that unless the tenant is able to take the matter on herself, or a local authority which has an entitlement but no obligation to assist in these circumstances steps in, then it's going to be, I think, a fairly meaningless remedy. I don't think you can realistically expect a tenant at the lower end of the market to act as a litigant in person, seeking to get back any money that may have been paid over. So that's a point which I wonder if it's been thought through. And it may be the way to deal with it is that one adds to paragraph 8 of Schedule 3 a simple point about a fixed cost regime, so that if a person is found to have charged a prohibited payment, then there'd be an amount of fixed costs, perhaps £500 or £1,000 to be paid in addition to recovery, which would make it financially viable for legal aid-based firms, for example, to actually assist in proceedings of this sort. They won't do it in a small claim situation, of course, because there's no funding at all. But a modest fee of that sort may do a great deal to enhance the practicality of what I suspect would be quite a small number of cases that might actually go that far.
Thank you for those points. You want to take that? And then come on to your own.
I just want to follow up on the issue of the apparent discrepancies that you mentioned in the drafting on the fines for letting agents. Given that the set of circumstances seem to be that the government are looking at multiples of the unauthorised payment on the fee or charge or whatever, do you think it should be commensurate with that, or should it be commensurate with the size of the letting agent's market? So, for example, a letting agent that has 1,000 properties on which they exercise the same view, if they're fined on one, it should then be applied to the fact of the 1,000 properties that they manage.
My view, I think, would be that simplicity is much the best route to follow in these circumstances, and so a fine which is simply related to the level of the fee itself would be much the most straightforward way to proceed. Anything that involves unstructured discretion will necessarily lead, I think, to a large amount of satellite litigation. Eventually the matter will have to work its way up through the courts, and the Supreme Court in 5 years' time will tell us exactly what the principles should be. So if that is not the route that's going to be followed in the legislation itself, I would certainly suggest it be followed in the guidance, so that at least we have something relevant, if not definitive, as to answering that question.
And in terms of the discrepancy that you mentioned earlier, how would you see that being best corrected? Because obviously we're doing pre-legislative scrutiny, and we'll give advice on what we think should happen, but given you've identified a discrepancy.
Well, a simple way, I mean, it may not be ideal, would be that you have a multiple perhaps of 3 for the Clause 7 first fine, and then you simply move on if a Clause 9 offence has actually been committed, that the multiple of 3 perhaps has increased to 10. That's a significant
increase. So ratchets up for more frequent offenders, basically?
Yes.
Okay, fine. So, looking at the other issues, this is maybe for everyone here. trading standards are being used within the legislation to enforce a lot of this. In your considered view, do you think they've got the necessary resources, and will the incentives be there to encourage trading standards to actually do this work?
Well, paragraph 10 of Schedule 3 does explicitly provide that local authorities may use such fines as they levy under this legislation to finance the costs of their activities. I would wonder if that means it's actually relevant for a local authority in fixing the level of a fine. As the bill now stands, say, well, we're going to charge this landlord £5,000 because even though she hasn't done anything particularly egregious, we need the £5,000 so that we can employ the enforcement officers who will go around and check that other, perhaps more egregious landlords aren't doing the things that we don't want them to do. That seems to be a matter that ought to be thought through in the bill itself.
I think another point, which is almost the opposite scenario, is local authorities who are very proactive about publicising the bill, about encouraging local authorities to comply, about educating tenants about their rights, will potentially be able to receive less in fines than those who do very little around the commencement and have a large number of problems brought to their attention. And I do think that is a slightly curious situation. And I think one issue we would like to see the department return to is actually whether there should be some upfront funding for trading standards as the legislation beds in.
Okay. And the final issue from me, tenants recovering unlawful fees via the county court, is that a reasonable position to take?
In principle, I think it's entirely reasonable, but I think in practice it's likely to be a complete nonsense and it will just never happen.
And there's a particular problem there around default fees. We were not comfortable with the entire concept of default fees as they're framed in the legislation, because at the moment contract law doesn't normally have penalties applied to it in that way. So there's something slightly curious about applying default fees to this. What makes us more nervous is the safeguard that the department proposes is that a default fee is legitimate if it covers something which is in the tenancy arrangement. But there's no guarantee that clauses in the tenancy agreement will actually be reasonable, and to challenge that you have to go to the county court, and that is quite a high burden for tenants to get over. So the temptation will just be to sort of accept it. Which is obviously kind of deeply unsatisfactory and problematic. So I think some of the risk of this can be removed by removing the provision around default fees and clarifying that the presumption is that the deposit is there to recover landlords' reasonable costs for instances like lost keys and that sort of thing, rather than creating this grey area of acceptable fees which need to be policed in a very kind of cumbersome way for the tenant.
Okay. Do you think that such fees should actually then be laid out very clearly in black and white so that everyone understands what they
Our recommendation would be to remove the provision for default fees full stop, and have the understanding that the deposit is there. I think from our point of view the Minister has sort of missed an opportunity to maximise affordability by allowing the deposit to be 6 weeks rather than 4. But as it is 6 weeks, that does mean you actually have a substantial sum of money held by the landlord, which can cover some of the costs that default fees seem to be proposed to address.
Okay, all right, thank you.
Okay. Right. Thank you very much indeed for coming to give evidence to us on a very wide range of issues. That's been very helpful to the committee. Thank you very much indeed. All order, that brings us to the end of public proceedings for today.
Meeting has ended.